Good evening, everyone, and welcome to our webinar on current medico-legal issues. I'm Tracy Pickett. I'm a Legal and Policy Officer at Avant within the Avant Advocacy, Education and Research Group. I'm pleased to be your moderator this evening. To begin, in the spirit of reconciliation, Avant acknowledges the traditional custodians of country throughout Australia and their connections to land, sea and community. We pay our respect to their elders, past and present, and extend that respect to all Aboriginal and Torres Strait Islander peoples today. Let me introduce our panel for this evening. First, I'm very pleased to welcome Dr. Michael Wright, General Practitioner and Chief Medical Officer at Avant. Michael is a Sydney-based GP and Avant's Chief Medical Officer. His career includes general practice work in both urban and remote settings across culturally diverse populations. Michael has been a practice owner and a salaried and contracted GP. Michael is also an experienced researcher with a PhD in health economics and is a strong advocate for improving Australia's health system. Good evening, Michael.
Hi, Tracy.
Next, I'd like to introduce Ruanne Brell, a Senior Legal Advisor in our Advocacy, Education and Research team. Ruanne has 20 years experience in health law and advises our members on a wide variety of medical and health law issues. She also actively advocates for our members in the preparation of submissions and other educational material as part of Avant's advocacy and education strategies. Having worked with Ruanne for some time now, I know that we're very lucky to have her as a presenter this evening. Welcome, Ruanne.
Thanks, Tracy. Hi, everyone.
And last but by no means least, we have our final panel member, Dr. Mark Woodrow, General Manager, Medical Advisory Services and Deputy Chief Medical Officer at Avant. Mark has worked as an emergency physician for over 25 years and is the current chair of the Wesley Hospital Quality Assurance Committee. He's also the Vice President of the Medico-Legal Society of Queensland, and he's an all-round great guy. Good evening, Mark.
Good evening. Thank you very much for that very kind introduction.
I'd also like to acknowledge our very knowledgeable and attentive elves who are in the wings this evening. Georgie Haysom, my boss and the General Manager of the Advocacy team, and Ruth Crampton, Head of Education at Avant, and Chris Wright, Education Specialist and Chief Button Pusher. They'll be doing their best to respond to the questions which are raised during the webinar in the chat. So let's get things moving. As you know, this evening, our advertised topics of discussion are telehealth, cosmetic surgery guidelines, and patient follow-up. In the lead up to this evening's webinar, we have received a number of questions relating to these and other issues, which we will attempt to respond to during the course of the evening. To frame our discussion, you will all be aware that the federal budget was handed down last week. Michael, would you kick us off on this State of Origin night by providing us with an overview of the budget from a health perspective?
Sure thing, Tracy. Look, and welcome everyone. Just a bit of a recap. So the Commonwealth Government's financial year 23-24 budget followed through on its pre-election commitment to prioritise primary care reform, and it delivered a $5.7 billion package to strengthen and modernise Medicare, with a lot of the focus on general practice. So the headline increase in Medicare funding included a $3.5 billion investment to triple the bulk billing incentives, which are paid to GPs when they bulk bill patients with Commonwealth concession cards or children under 16. And that'll be introduced from July 1. These incentives are scaled so that they provide greater support to rural and remote areas, but there's no obligation to bulk bill these patients, and practices can continue to privately bill if that's their business model. And then I think the other main thing to report is there are a number of other incentives which were introduced, which will be introduced, which align with recommendations from the Strengthening Medicare Task Force, which presented earlier in the year. So there's $445 million to expand the general practice stream of the Workforce Incentives Program. So that'll provide additional support for general practices to employ more nurses and allied health professionals by both increasing the maximum incentive that practices can receive up to $130,000 per year and making more practices eligible for the program. The government's also announced additional funding over 5 years for 8 more Medicare urgent care clinics. And then there's also some emerging detail about a new program which is going to allow patients to enrol with the practice of their general practice of their choice in a program called My Medicare. And so within that, there's an additional $98 million where hospital frequent flyers are going to be connected to general practices through their PHNs to receive comprehensive multidisciplinary care. And within that program, practices will be eligible for a $2,000 upfront annual payment for looking after these people. There'll be some additional funding that comes along with that My Medicare program, including additional access for telephone consults greater than 20 minutes for enrolled patients, and more detail about that program is emerging. I think that's a snapshot, Tracy.
Thanks, Michael. And it's fortuitous that you raised the issue of telehealth, because our audience members may not be aware of the hot off the presses new telehealth guidelines, which were released this afternoon at 4:14 by AHPRA and the national boards. Those guidelines had to come into effect on the 1st of September 2023. Ruanne, I wonder if you could open our discussion on telehealth by explaining what is telehealth from the regulator's perspective.
Yeah, sure. Thanks, Tracy. So as Tracy mentioned, these guidelines come in on the 1st of September. Up until that point, there are existing guidelines in place. And from a definitional point of view, the current definition that's in those guidelines has been tweaked slightly. And under the updated guidelines, the term telehealth consultation is described to refer to any consultation that uses technology as an alternative to an in-person consultation between a doctor and a patient. So that might be video, internet or telephone consultations, transmitting digital images or data, and prescribing medications through one of those telehealth sort of platforms. This has been revised and tweaked a little bit since the previous definition. So it's also probably good to just look at what's not included. So those are things like remote patient monitoring and technology that's used during a consultation that's otherwise in person between the doctor and patient.
Thanks, Ruanne. And that leads me to an indemnity issue, which we should cover off on. I might ask Mark to address this question. Mark, some practitioners suggest that they are undertaking telehealth when they carry out what is effectively tick box or asynchronous medicine. That is, the practitioner does not have any direct or real-time interaction with the patient, either face-to-face, via video or telephone. Can you explain why Avant is not indemnifying practitioners for asynchronous medicine?
Yeah, thanks very much, Tracy. As we know, telehealth has been around for a while, and it provides enormous benefit in the delivery of healthcare, especially to remote and regional areas. Its acceptance sped up quickly with COVID and the development of supporting technology. However, as we know, a telehealth consultation is not the same as the traditional face-to-face consultation, and carries not only an increased administrative burden to satisfy Medicare requirements, but also an increased medico-legal risk. Avant supports the use of appropriate telehealth. Asynchronous telehealth, or tick box healthcare, is a different beast. So this is when a consultation is undertaken without any direct contact or pre-existing relationship. There exists several risks over and above other forms of established telehealth: reduced ability to confirm identity, lack of non-verbal communication, absent relationship of mutual trust, inability to effectively undertake shared decision-making or ensure understanding for consent purposes. The Good Medical Practice Code of Conduct for doctors in Australia still applies. In our opinion, and supported by the Medical Board, asynchronous telehealth represents a poorer quality of healthcare that carries a significant risk of harm to patients. And this is supported by complaints to regulators and claims data. This is why Avant has made the decision to not indemnify asynchronous telehealth. Again, I reiterate that Avant does support telehealth, consistent with the Medical Board's guidelines, telehealth consultations with patients, which is effective from the 1st of September. That is, when there is an established relationship with the patient.
Thanks, Mark. While I've got you, we have received a question from an audience member who asks, can you undertake a telehealth consultation for a new patient? Can you help us with that question?
Yeah, there's a bit of a difference, I guess, between whether you plan on billing through Medicare or not. For Medicare billing, it is a legislative requirement that GPs and other medical practitioners working in general practice must only perform a telehealth or telephone service where they have an established clinical relationship with the patient. An established clinical relationship is defined as medical practitioner who performs the service has provided a face-to-face service to the patient in the last 12 months. The medical practitioner who performs the service is located at a medical practice and the patient has had a face-to-face service arranged by that practice in the last 12 months. And this can be a service provided by another doctor at the practice or a service performed by another health professional located at the practice. Or finally, the medical practitioner who does perform the service is a participant in an approved medical deputising service. And that service that employs the practitioner has a formal agreement with that medical practice.
So that's obviously why tick box medicine isn't covered by Medicare. And that's interestingly also referred to obliquely in the new guidelines. Another question we've received is, can you bill Medicare for telehealth consultations if the patient is overseas?
The answer to that question is no. A fundamental Medicare principle applies here, prohibiting the payment of Medicare benefits for services provided outside Australia. Under Section 10 of the Health Insurance Act 1973, Medicare benefits are only payable for professional services rendered in Australia to an eligible person. That is, both the patient and the health professional must be physically present within Australia, as defined in the Act, for a Medicare benefit to be payable. This legal requirement applies to all Medicare services, including telehealth services. Where a Medicare item cannot be claimed, the medical practitioner may choose to raise a private fee for the service. Under the principles of informed financial consent, patients should be made aware in advance of the costs of the medical services prior to any service being provided. And the patients are also required to be advised where or where not Medicare benefits are payable prior to providing the service.
Thanks, Mark. We might now move to the next topic for this evening's discussion, which is cosmetics. The new guidelines in this area will come into effect on the 1st of July, 2023. Roanne, could you tell us, in 50 words or less, why everyone is talking about cosmetics at the moment?
Yeah, sure, Tracy. I'm not sure I can do it in 50 words, but we'll try. So just to set the scene initially within that 50-word limit, from 1 July 2023, so in about a month, there's some new guidelines that have been put out by the medical board that cover advertising of cosmetic surgery and a revised version of the board's guidelines in relation to practitioners who perform cosmetic surgery and cosmetic procedures. So before we go into more detail, we're just going to put up a bit of a poll question to see what our audience might already know about the application of the guidelines or what we're going to fill them in. So as the poll question there shows, which of the following do the updated guidelines not apply to? Cosmetic surgery, reconstructive surgery, cosmetic injectables, or you might not be sure. While we're waiting for you all to have a chance to submit an answer to that question, it's worth noting that the guidelines that we're talking about tonight are one part of a bigger sort of raft of changes that are due to come in a rolling sort of system over the next few months, following various reviews of the cosmetics industry that have been going on for about the last 18 months. So there's still further changes that are under consideration that are sort of in the wings, such as the national licensing framework for the facilities where any cosmetic procedures, cosmetic surgery might be performed. So if we have those results up, which of the following does it not apply to? About almost 50% of you said reconstructive surgery, which is the right answer. 30% of you were unsure, so hopefully we can answer some of those questions, but it certainly does, those guidelines certainly do apply to cosmetic surgery and cosmetic injectables. Other than reconstructive surgery, it's also just worth noting that they also don't apply to gender affirming surgery. So when we're talking about the guidelines, and we'll drop the link in the chat for you all, we're talking about the revised version of the guidelines for medical practitioners performing cosmetic surgery and procedures. And then there's a new set of guidelines, brand new, to supplement the current advertising guidelines that apply to all medical practitioners and anyone advertising a health service. And those are specifically for advertising cosmetic surgery. In the interest of time tonight, we're going to focus a little bit more about the guidelines because they have relevance for all practitioners. So those apply to those of you that might be performing cosmetic surgery. They also apply to those of you that will be doing cosmetic procedures, so non-surgical procedures. There's also relevance for any other practitioner because of a requirement which we'll talk about, which is a new requirement that a patient seeking cosmetic surgery must have a referral from, ideally from their usual GP. The board says, or if not, from another general practitioner or a non-GP specialist practitioner. There's a few other changes, and the most important thing, if you can take anything away from tonight, would be to read the guidelines. But there's a few other things in there. So some of those changes are that there has to be, for cosmetic surgery, there has to be at least two consultations before the surgery is performed. At least one of those must be in person with the medical practitioner who's going to perform the surgery. And the first consultation must be with the practitioner who will perform the surgery or another registered health practitioner who works with that medical practitioner. It's also worth noting that the consent forms can't be signed at the first consult and can only be signed after the patient has had an in-person consultation with the medical practitioner who will be performing the surgery. And the other requirement is that a medical practitioner who will perform the surgery must assess the patient for underlying psychological conditions such as body dysmorphic disorder using a validated screening tool. And the surgical ones, will touch on the non-surgical changes in a little minute.
Ruanne, we had received a question online about whether we can suggest a body dysmorphic disorder screening tool, presumably in relation to the requirement that you just mentioned. Are you able to comment on that?
Yeah, so that's ultimately really a clinical question. So as I just mentioned, the requirement is that the person performing the surgery uses a validated tool. So in the first instance, we'd encourage our members to go to their relevant college or society and get some guidance about what tools might be available. We're aware of a tool such as the Body Dysmorphic Disorder Questionnaire, and we're aware that some other tools might be under development, or given this new requirement, we anticipate that the colleges will be sort of putting together resources for their members to guide them in terms of the most appropriate tool.
So what about non-surgical procedures? Are you able to provide us with some insight regarding the distinction between non-surgical procedures in comparison with procedures which involve a cutting beneath the skin?
Yeah, so in the revised guidelines, that's the distinction made. So the new definitions are cosmetic surgery, which involves cutting beneath the skin, and there's some examples provided, but that's not an exhaustive list by the board in the guidelines. The non-surgical procedures are those that involve piercing the skin, such as cosmetic injectables, laser hair removal, as some of the examples given in the guidelines. These don't require a referral from a GP or other practitioner as cosmetic surgery does, but there are some other requirements, such as that the practitioner who's going to perform the cosmetic procedure or prescribe the injectable must conduct a similar assessment for of the patient for an underlying psychological condition, but it doesn't include the same mention of that being using a validated assessment tool. The medical practitioner who is prescribing the injectable must have a consultation with the patient each time they prescribe the Schedule 4 injectable. That can be either in person or in video. So we had a question come through that I saw about whether or not you can use asynchronous care. So that would not satisfy the requirement. It needs to be in person or by video, so a real-time consultation. And it's also just interesting to note that the board has included advice that it considers that Botox and dermal fillers should not be prescribed to patients under 18 for cosmetic purposes. Again, so the guidelines are separated into two sections, basically, or an introductory section and then a separate section for cosmetic surgery and a separate section for cosmetic procedures. So we'd encourage you to sort of read those and dissect them. And you'll see one of the things that we'll direct you to tonight is the FAQs that the board are constantly updating in advance of the 1 July effective date. So again, just sort of keep checking back, and we'll obviously be keeping our members informed about this sort of as time approaches.
Roanne, in relation to the requirement in the guidelines for a referral for cosmetic surgery, can you tell us what obligations the referring practitioner has?
Yeah, sure. So it's important to note that, I mean, realistically, all our practitioners have always had an obligation when providing a referral that it's appropriate. Because this is a new requirement, the board has put out some FAQs that explain the sort of the referral, and those are sort of being constantly updated as questions come in. Essentially, so that referral is to be provided by the usual GP for that patient, or by another GP or another non-GP specialist. That practitioner for that referral needs to be someone that does not provide cosmetic procedures or cosmetic surgery. But a cosmetic practitioner can on-refer a patient. So if you are referred a patient and it's for a procedure that you don't do, you absolutely can on-refer that patient to another surgeon who does do that procedure, as long as that patient has that initial referral from their usual GP or other non-cosmetic practitioner. When we're talking about the practitioner who's providing that referral, the board absolutely recognises, and this is outlined in their FAQs, that they do not, that practitioner, the average GP who's never had to do this before, is not expected to have an in-depth understanding of cosmetic surgery or the particular procedure the patient's asking for. The purpose of that referral is really about providing accurate and up-to-date information about the patient's history to the doctor that they're referring to. And part of that process also, the board notes in their FAQs that the doctor providing the referral can access the AHPRA's public register to find out details, particularly if the patient obviously comes requesting a referral for a particular practitioner. As I said, these FAQs are being updated on a fairly regular basis in the lead up to the 1 July implementation date.
Roanne, I just see that there's some questions coming through in the chat, and I don't know whether you'll be able.
Yeah, so I can see some of those, and probably some of them have come in while we're talking. So the most recent one is, so if the patient's usual GP does the occasional injectable, must the patient go to a GP that is not their own? So good question. The way that it's referred to in the guidelines that the practitioner can't be someone, and I'm just going to pull it up as we're talking, that the practitioner can't be someone that provides cosmetic surgery, I believe. Sorry, give me 1 second. And so they're, non-surgical cosmetic procedures. So depending on what you meant by the occasional injectable, if it was, it would be probably better to I suppose to look at whether or not you could provide that referral sort of accurately and objectively to the patient. What we are doing at the moment is gathering questions and actually liaising with the board to sort of make sure those FAQs are updated and responsive as possible. So the wording of the FAQ is that the practitioner, and sorry, I had it and now I've just lost it, but that the practitioner can't provide surgery or cosmetic or non-surgical cosmetic procedures. So on a strict reading of that, I would say the occasional injectable is someone that provides a cosmetic procedure. But if that was a very minor part of your work, then I think that's something that we can absolutely sort of get clarified for you. I've just seen another question that's come through saying, can we refer patients to non-AHPRA practitioners? I presume by non-AHPRA practitioners, that questioner means that someone who is not a registered health practitioner. The easy answer to that question is no. So the referral is for cosmetic surgery. Someone who is not a registered medical practitioner should not be providing cosmetic surgery. And part of the guidelines states that anyone performing cosmetic surgery must have the appropriate qualifications and skills and training. One of the other changes that was brought in is the introduction of an endorsement for cosmetic surgery, which is, whilst the registration standard comes into effect on 1 July, no training programs have yet been approved because it's only just come in and it's all underway at the moment. So if you were faced with a patient who was requesting a referral for a surgical procedure to someone by name and you could not find them on the AHPRA's public register, then that would not be someone that would be appropriate for you to refer to for a surgical procedure.
There's also some other questions coming through, particularly about the timing of patients between the start of the guidelines, and so patients who are between procedures.
Yes. So helpfully the board have addressed that in their FAQs too. So basically, if you've got an existing patient that you haven't yet performed surgery on and you are going to perform the surgery on that patient prior to 1 July, then you would be doing that in compliance with the existing guidelines, which are in place at the moment. If you have seen a patient and you are having ongoing consultations with them, but that surgery is going to take place on or after 1 July, then you need to make sure that you comply with the new guidelines. If you see a patient, if you've got a patient booked, but the first time you are seeing them is after 1 July, then the whole of your treatment will then come under the revised version of the guidelines. And there's basically a cascading answer to that in the FAQs from the board.
There are a number of questions coming through about how to check whether a practitioner is registered. There is a AHPRA register online, which we can put the link to. And one of the questions was, do we have to check each time we make the referral? I would have thought the answer is yes.
Look, as the lawyer, I will say that, and the board's guidelines, the board's FAQs have indicated that it certainly appears, and again, this is something that we are clarifying with the board, that the expectation is, particularly given this is a new area, and it's not like as a referring doctor, you will have up-to-date knowledge about who might be the most appropriate person for that patient to see, much like you might have with some of your other specialty referrals. The board has made it clear that that checking the public register, so doing a name search of that person, for example, is the appropriate way of determining that you're referring to someone, referring to an appropriate person. If you search the register and it does not return any results, then the suggestion would be that that person isn't registered. The more likely situation is that your search will return a result, but then you will need to click on that person's name and ascertain, for example, do they have specialty registration? Do they have any surgical qualifications? Some of you may have looked up yourself on the AHPRA register or may have recently interacted with it, but basically it lists when someone has obtained their registration for the first time, it'll list that their registration is current. So most of those at the moment will obviously have a date of in 2023. And then it will go through whether they've got general registration, whether they've got any specialist registration. And then, as I say, there's a qualification section, which would list any, not only their MBBS, or an international qualification, but also any fellowships to a college, for example.
And there have been some comments coming through to the effect that that's a lot to do in an 8-minute consultation.
So yes and no. If you're not familiar with the AHPRA register, it's probably worth, like, you basically go to the homepage. I think we've had the link put in there. In any event, you go to the homepage, you choose medical practitioner, you type in the name of someone that's the patient's requested, if that's the situation, and you see what's there, and if they're and then you can have a conversation with the patient. This is, we absolutely appreciate, a new area, and that is one of the reasons why we are constantly liaising with the board, and we've waited to do that until after tonight so that we can actually take our members' questions to the board and make sure that come 1 July, particularly in relation to this referral requirement, that we have some information to give you about how this requirement is going to play out. Yes, that part of it is not timely. What then happens next in terms of the discussion you have with the patient is obviously something that will, be a new area and will develop in terms of the sort of the nature of the consultation. I just saw a question come in there about whether the referral is you can get a rebate from Medicare for that. So the consultation that you have with a patient, although cosmetic surgery generally is not rebatable through Medicare, that consultation is as a consultation that the board has gone to Medicare and clarified that would be, obviously assuming that you meet all the requirements of your item number as you are normally required to do, that consultation could attract a Medicare rebate.
And it's really important, I suppose, given that this is a newly developing requirement and new guidelines, the FAQs are the best place to start. Keep an eye on, because as the questions are being asked by practitioners, we're putting it, or AHPRA are putting those responses up. So that is the best way to keep informed as to what the current status of these questions are. And there's more questions coming through about referrals.
So look, Tracy, I'd absolutely agree, and I'll probably mention it a few more times, that certainly checking back in with the FAQs as the effective date approaches. They were last updated, I think, when I on about that. So there's sort of a few different versions, but certainly there's a specific FAQ in relation to the requirement for a referral, and those FAQs were last updated about 5 days ago. And they will keep being updated. As I said, we are collating questions and we'll be taking them to the board so that those FAQs are as appropriate as possible to answer the scenarios that our members are facing.
Thanks, Ruanne. That's really helpful. And more questions on cosmetics. So back to Ruanne.
Yeah, sure. So I apologise if there are some that I can't see, so there's a couple there. Is it mandatory to send the correspondence from a cosmetic surgeon to GPs as we refer the patient? So no, there's no requirement for you to send the referral, if I understand the question correctly, for you to send the referral to the surgeon that you've referred to. You can give that referral to the patient and they can take it with them. What the board does anticipate and hopes is that, much like with any other referral, that the surgeon will then report back to you as the GP, so that continuity of care loop is closed. One of the other questions is whether or not you're allowed to say no, and certainly the board has made it clear that yes, you are able to decline to provide a referral for a patient for cosmetic surgery if you're not comfortable doing so, and I'd just suggest that you sort of explain why that might be the case. You're also able to explain, and this goes back to what we were talking about in terms of the public register, you are also able to explain that you might be uncomfortable providing them to the named practitioner that they've requested, particularly if it's the case that, as we were talking about, where you couldn't find them on the AHPRA register and you weren't aware of who they are. So what you might be saying is, look, I'm happy to provide you with the referral to a cosmetic surgeon, and you can then make some inquiries about who the appropriate person might be, but you're not comfortable providing a referral to the person that they've requested because whatever the reason might be, because I can't find them on the AHPRA register and that indicates they might not be registered, etc.
Just another one I just saw is whether they would be held responsible if they do provide the referral. Do you have a comment on that one?
Yeah, so, and I think, Tracy, that question was asked in the context of if the patient's got a concern about this, about the procedure after the surgery has been performed, and might seek to bring some sort of action against the surgeon, and would the GP also be liable? So all doctors with any referral are required to make an appropriate referral in the patient's circumstances. It remains to be seen in terms of how the referral, or whether I suppose it's going to happen, that doctors might be joined to complaints, or it's sort of included in complaints or joined to proceedings if there was a concern about the surgery. But the board's made clear in their FAQs that the practitioner providing the surgery has clarified that they're responsible for the surgical care and management of the patient, not the referring GP. So you're obviously, as a referring doctor, GP or other non-GP specialist, are not responsible for the way the procedure has been performed, but you are obviously responsible for providing an appropriate referral. And that, you know, and what that's going to involve is going to unfold a little bit over time. I also just saw a question about the body dysmorphic disorder assessment. And just to clarify, that's an obligation on the person performing the surgery, on the medical practitioner performing the surgery. It's not an obligation on the GP. And so that, you know, so that's not something that the general practitioner or the referring doctor needs to do before providing the referral.
Thanks, Roanne. I've just seen another one. I realise we're jumping around, but we're trying to answer your questions as you put them up for us. One of the questions regarding telehealth says, if you do a telehealth consult through phone or video and prescribe a medication to a patient, for the consequent visit, can you prescribe the same medication if the patient requests it through text or email without a telehealth consultation? The new guidelines, which everyone should read, that were issued this afternoon, they make it very clear that telehealth consultations are to be judged by the same criteria as a face-to-face consultation. There still has to be a good standard of medical care for the patient. So, one, I would query receiving a patient request via text or email, because there's no assessment there of the patient's condition. And also, if a request by text from a patient is received, that's not going to substantiate a medical record of any substance by which you'll be reviewed. We might move forward with the next issue that we're going to discuss tonight, and that is the issue of follow-up. As some of you may be aware, Avant has recently been involved in a case related to follow-up, and there has been a recent Court of Appeal decision on this topic. For those who are not familiar with that case, it involved a GP who worked in a multi-doctor clinic in Canberra. The GP was consulted by a patient who had pain from a hyperkeratosis, or a corn, on the sole of his right foot. Between July 2013 and August 2016, the patient attended on approximately 19 occasions with that defendant GP. On the 6th of April 2014, the GP referred the patient to a surgeon working in general surgery at the Canberra Hospital. The GP saw the patient again on the 2nd of May 2014, and at that time, the patient had not received any response from the hospital regarding the GP's referral of the 6th of March 2014. The GP then sent another referral letter to the hospital surgeon. No response to either referral was received from the hospital or the surgeon. And for the next 2 years, the patient was mainly treated with painkillers. In August 2016, the patient's foot became infected and extremely painful, and he was admitted to the Canberra Hospital at that time for acute care and surgery to drain an abscess. The patient sued the GP, seeking damages and negligence. Michael, this situation might lend itself to a Zoom question for our audience.
Yeah, thanks, Tracy. I think you're right. Why don't we have that poll question, and then we might talk about what happened in this case. So here we've got the question: who do you think should be responsible for follow-up in this case? The GP, the patient, the hospital, or all of the above? Now, as always, when you see these questions, see these cases as a GP, a little bit frightened by this, but I'll wait for our response and then I'll tell you what happened. Okay, so all of the above. So a bit of sharing, so 11% for the GP, 12% for the patient, 14% for the hospital, and 60% saying that there's some shared responsibility. Well, let me run through what happened. So in the original case, the judge ruled the doctor had a duty of care to follow up the referral if the patient hadn't been seen within a reasonable timeframe, which the judge deemed to be a month. And the court found that had the doctor followed up the referral, they would have discovered the referral pathway was ineffective and been able to take measures to have the patient seen by a specialist for some initial advice. And the judge found the GP was negligent and entered judgment for the patient to the sum of $190,000. So the GP's medical defence organisation, which was Avant, supported the GP to appeal the decision, and the appeal turned on what precautions a reasonable GP would take to guard against the risk of harm to the patient and whether any breach of the doctor's duty of care caused the injuries. So in handing down its decision, the Court of Appeal confirmed that a doctor may have a duty of care to follow up a referral, but this depends on the facts of the case. And so in this case, the Court of Appeal accepted Avant's argument that the doctor didn't have a duty of care to follow up the referral, as a reasonable GP in this case would know that it was futile unless that there was a significant deterioration in the patient's condition. So just to explain, the GP in this case had been working in the local area in 2012, had experience of the referral process at Canberra Hospital, and gave evidence that, in his opinion, even if he were to telephone the hospital's outpatient clinic to follow up the referral, it was unlikely that an earlier date would have been given. And it was the GP's opinion that the wait times for Category 3 surgery, such as this patient's, would take more than a year. So based on that information, then the Court of Appeal held that the circumstances which are significant to the particular jurisdiction or location are relevant if it means that the precaution which is suggested is less likely to guard against the identified risk. And so in this case, in Canberra, the GP knew if he were to call the hospital to follow up the referral, even though it had been a significant period of time, the telephone call was unlikely to have the effect of changing the patient's appointment. Furthermore, the Court of Appeal rejected the finding that something had gone awry in the hospital's processing of the referrals. Instead, the delay was found to be nothing more than the normal operation of a significantly overstretched public health system, which had the patient on a long waiting list and allocated low priority. So the claim was dismissed, and the patient was also ordered to pay the doctor's costs. Since then, the patient has applied for special leave to appeal, so there may be further judicial comment on this case.
So very relevant, the doctor's experience of working in Canberra and what he knew to be the case for the usual wait times and so forth in that jurisdiction.
Yeah, definitely. And look, and I think it raises a lot of questions around, what are your obligations to follow up patients? So whether it's a referral or whether it's investigations.
So as a GP, Michael, what do you consider are your obligations in relation to follow-up?
Well, I think we could do a whole other webinar about follow-up. So we won't have time to do all of that. But I think, look, it probably to put down a few basic rules, the obligations can vary, according to whether you or someone else has ordered a referral or investigations. And in simple terms, if you order a test or a referral, then you need to take steps to make sure that they're acted upon appropriately and that results are communicated in a timely manner. But, patients are entitled to decline your advice or to not to have follow-up. But despite that, you're expected to make some reasonable attempts to follow them up, particularly on what you call clinically significant investigations and assessing clinical significance. You can do that in a number of ways, but that would include assessing whether the patient's condition is potentially serious or life-threatening, assessing the risks, what would happen if the patient did delay the test or not have the test, and particularly about, what's the significance of any abnormality or result or report that you've seen. And, for instance, there's different clinical significance in ordering tests for chest pain versus those for routine monitoring of something like cholesterol. Look, Avant's got a lot of fact sheets about this where we outline steps and systems that you can, as a doctor, and in your practice, that you can take to ensure appropriate follow-up, including things like the recording of results, having recall systems.
Michael, one of the questions in the chat was, why wasn't the government held responsible? And I think we'll have a whole other webinar on that
Yes.
health resourcing topic. But another question that's come up, what if you tell the patients to follow up with the hospital and if nothing has been heard to come back to you? Do you have a comment on that?
Look, as I said, there's no simple answer in that it is about clinical significance. If you think it's important enough that the patient needs to follow up, the level of follow-up that you think should need to be happen is graded by what you feel is the clinical significance of a test. So bearing that in the back of your mind.
I'll lead you on to the favourite one for GPs. What about when the issue to be followed up is recorded in the hospital discharge summary, which may or may not find its way to your desk? What do you do?
I suppose, yeah, the absent discharge summary, or even better, when you do get the emergency department discharge that says GP to chase. The GP to chase message is a bit of a trigger point for many GPs. I think on a serious note, though, fundamentally, the person who has ordered the test has the obligation to review and action the results. So just saying in a letter, GP to chase doesn't change that responsibility. So if you see someone in an emergency and you're worried about a result, you need to follow up and make sure that that information is actioned by the usual provider. But then in a slightly different situation, sort of as a GP, if you receive a discharge which contains abnormal results, which warrant follow-up, then once you have that knowledge, there's a reasonable expectation that you should take action, even if you didn't order the test. So obviously the need for you to take action changes with the seriousness of those results. And once again, we've got some fact sheets that explain how to manage these different situations.
I might turn to the emergency physician to answer this one that we've just received. If a patient declines follow-up and fails to attend, is it still the GP's responsibility? Mark?
Well, the follow-up of patients and results is and always has been identified as an area of risk. The issue of whose responsibility is it is always central. Whose fault is it when the patient doesn't follow up as recommended? The courts have always been keen to extend our responsibility, but ultimately, as been said before, excuse me, it swings on the particular circumstances. There have been cases critical of the doctor for not following up appropriately, but also cases where the patient's repeated non-compliance defeated his claim. I would say, rather than seeing it as a question of who's to blame, ask instead, how can I achieve the best outcome for this patient? Going back to the question, how far do we go? There's a lot of things to consider, and sorry if I'm reiterating a lot of points that Michael has already made. The nature of the condition, what is the clinical significance? Are there patient circumstances? Can they afford to comply with your recommendations? Are they likely to follow up? Is mental health a factor in their decision-making? There's practitioner and practice considerations. Can you follow up or someone else has to do it? And remember, as Michael said, the basic tenet is that if you order the test, you're responsible for it. Now, that responsibility can be handed over, but it needs to be handed over properly. And the vexed question, what if you didn't order the test? Again, as Michael has said, you can't unknow information that you've received. And if it is a significant result, you should contact the ordering doctor or inquire with the patient directly about how the result was being followed up. Again, think about the best outcome for the patient. A safe habit to consider would be to think about what might happen before there is a failure to follow up. As the saying goes, an ounce of prevention is better than a pound of cure. You should be explaining what the test or the referral you are recommending and why. How important is it? How urgent? What are you concerned about? What are the consequences of not proceeding as recommended? You should involve the patient, preferably in a shared decision-making model. This will have them a bit more invested and hopefully more compliant. And then document that this advice has been provided. Consider writing that information down for them. This process may also help you to reflect and think rationally about the referral or the investigations and the clinical appropriateness of them. Again, the important part here is to have a system to check if it has been completed in a reasonable amount of time, a reminder for the patient, a reminder for the doctor. And it's always very important to ensure that you do have the correct contact details. So how far do you go? Well, we would normally sort of nowadays send a text reminder, possibly a phone call, an email, and if those fail, even a registered post. Rarely the case. You may need to confirm contact details with a pathology or radiology provider, contact relatives or friends, or in extreme circumstances, ask the police to track the patient down. How far you go depends on the circumstances, assessing the risk to the patient and medico-legally to yourself and acting appropriately. Again, as Michael has said, Avant has abundant resources to assist in this regard.
Mark, I might just add in a question that's just been received and I might be able to respond to. It says, if considered appropriate and pre-agreed with the patient, can you use the patient practice's SMS software to send an SMS with a simple result? That is, your cervical screening result was normal, repeat in 5 years. I would not send that detail in an SMS. You can use SMS certainly in relation to messaging and appointments and all of those other things, but details regarding a cervical screening result, be it normal or not, you have to bear in mind with SMS that phones messaging can be on display. So problems arise when other people might see that message and the confidentiality for that message is gone. So those are the things you have to bear in mind. I would have thought. Mark, do you have a view on that?
Yeah, absolutely. It does depend on the nature of the result. If you're just letting someone know that their COVID test is negative or their flu test is positive, then that's possibly reasonable if it's been prearranged and you've confirmed the details. I'd normally be very cautious about the content of what you're actually sending, so that to be honest, I would not include their name, so that if someone else gets the result or sees the result, they don't know who it's actually about. But once again, those issues that Tracy raises are very important, and probably a better response is to have them call the practice so you can speak to them directly.
Mark, I'll just ask you this question through the chat as well. What is the current best approach when a patient self-discharges from a facility against medical advice after anaesthetic for a day procedure?
So the discharge against medical advice form has always held place in hospitals as proof that they're leaving the hospital without your approval. I'm not sure that actually holds a great deal of medico-legal weight. More importantly is having a discussion with the patient about the consequences of them leaving and the consequences of them not complying with your advice. If they understand the risks and you believe they have capacity and they're making a decision against your recommendations, then you can document that. But ultimately in our society, autonomy seems to trump pretty much any other sort of ethical consideration, and the patient can feel free to do something, even if it's against their best interests, if they're able to make that decision themselves. Now, if that decision does have consequences for public health, that's a bit more of a difficult situation, in particular if they leave the day surgery and go and hop in their car, then that has significant consequences, and you may need to reconsider on ethical principles what is the appropriate action to take. Again, this would be a topic that could take an almost entire webinar.
And as our time is coming to an end and it's State of Origin night, I might ask for some closing thoughts from each of our panelists. Michael, can you give us your closing observations first, please?
Look, thanks, Tracy. I suppose first thing is just with the telehealth guidelines. They've come out today, so we're still looking at them. They are designed to discourage people from getting care without any contact with the patient. So if you know the patient and you communicate by other, you don't have to have a face-to-face consult after you know that you can use alternative means, but your obligations around maintaining privacy and confidentiality and documentation still remain, no matter what type of modality of consultation you might offer. And with the cosmetic guidelines, obviously coming in 1st of July, thanks everyone for identifying a number of issues with those, that we'll be taking that information back. And my apologies, I think I misspoke before. The bulk billing incentives coming in November, not 1st of July. It's just the cosmetic guidelines from the 1st of July.
Thanks, Michael. Ruanne, your closing thoughts.
Yeah, so look, I would really just encourage you all to read the revised cosmetic surgery and procedure guidelines. And if you are performing and advertising cosmetic surgery, then read those new guidelines as well. As Michael said, and as I mentioned earlier, we'll certainly be taking the questions that you've sought clarification on tonight to the board, and please just keep checking back with the FAQs so that they can be as as up to date as possible and reflect those questions.
Thanks, Ruanne. Mark, your closing thoughts.
Yeah, so remember, Avant supports telehealth, but not asynchronous telehealth, as we consider it poor quality healthcare. In regard to follow-up, consider all the circumstances, assess the risk and act accordingly, and go the Maroons.
I'd echo those sentiments, Mark. Thank you to each of our panel members and also to the elves who have been working frantically to answer the questions in the chat. I'm sorry we haven't gotten to all of your questions, but we'll see what we can send through in the next day or so. Please be aware that the information which has been provided this evening is general information. If you do need specific advice, you need to take advice from your lawyer. If you have further issues you'd like to discuss, please visit our website, which is avant.org.au, or phone our Medico-legal advisory service on 1800 128 268. Thanks for joining us this evening. See you next time. Go the Maroons.